Good afternoon, everybody, and welcome to the latest webinar presented by 2 Temple Gardens. Today, I'm going to be talking about a very recent Court of Appeal judgment delivered last week in a case called Holmes and Poeton. It's a judgment about the material contribution test of causation. I'm going to be talking about the judgment itself in a little bit of detail and tell you what I think it means. And Howard Palmer KC is then going to follow my talk, and he's going to situate the judgment for you in a little bit of a broader context about causation. Now, Holmes and Poeton was a personal injury case, all about a gentleman who had worked for Poeton, the defendant, his entire adult life. It's a very sad case. In a nutshell, Mr. Holmes's case was that during his working life, he was regularly exposed to a negligent amount of a substance called TCA, which was a solvent, and his case was that as a result of that, he developed Parkinson's disease. He did not try to argue in his case that but for the negligent exposure to TCA, he wouldn't have developed Parkinson's. He squarely put his case under the material contribution test of causation. So he said, the exposure to TCA materially contributed to my injury, and that's enough for me to establish liability for 100% of my Parkinson's disease. He succeeded at first instance in the county court in Cardiff, and Poeton, the defendant, appealed, hence the decision of the Court of Appeal last week. Now, many of you will have come across the material contribution test of causation, and so you will know that this is an important area, because if it's possible to argue a case on the material contribution basis, then a claim can succeed even where a claimant cannot demonstrate that but for the negligence, they wouldn't have developed their injury. So it has the potential to increase the number of claims that are successful, and it can really impact them. Now, before delving into the judgment in a bit more detail, I'm going to cut straight to the chase to tell you what the judgment says. The Court of Appeal confirms that the material contribution test of causation can apply to indivisible injuries. This has been a contentious area on the authorities for many, many years, and frankly speaking, the authorities were in a state of complete mess, with a number of High Court decisions over the last few years going both ways, some saying the test can apply, others saying it can't apply, and equally, the authorities at the appellate level have been a mess as well. So this judgment is important in that the Court of Appeal really gets to grips with the issues, analyses a number of competing authorities, and sets out clearly what the view of the Court of Appeal is. So it is an important development in this area, clearly in favour of the position that the material contribution test does apply. So the first important point, I think, about the judgment is that the Court of Appeal makes a clear distinction between divisible and indivisible injuries. And so those of you who are looking for a quick guide to the most important meaty parts of the judgment, I think the first place to look is paragraph 31, where the judge, Lord Justice Stuart Smith, explains the difference between a divisible and an indivisible injury. And he says at paragraph 31 that a divisible disease is one which, once it's initiated, its severity is influenced by the total amount of the agent that has caused the disease. So a classic example from the personal injury world is noise-induced hearing loss. Quite simply, the more excess noise you're exposed to, the worse your hearing. And so the severity of the disease is directly affected by the amount of negligent agent that you are exposed to. By contrast, he says, an indivisible disease is one which, once it's contracted, its severity will not be influenced by the total amount of the agent that caused it. And a nice, neat example, I think, of that type of disease is a case which many of you may know called Bailey from 2008, where the claimant had a generally weakened state caused as a result of various things, and because she was in a very weakened state, she choked on her own vomit and suffered a cardiac arrest. Now, the cardiac arrest either happened or it didn't. Its severity wasn't influenced by the degree of weakness that the claimant had. It was simply that the total amount of weakness that she had triggered the cardiac arrest. So it's a useful distinction encapsulated in a couple of sentences in paragraph 31 of the judgment. And the other important paragraph for you to know is paragraph 63, and that's where, in very clear terms, Lord Justice Stuart Smith says that the Bonington material contribution principle applies to cases of indivisible injury, and where the principle applies, the claimant does not have to show that the injury would not have happened but for the tortious exposure. So that's the real heart of the decision, is paragraph 63. Now, how did Lord Justice Stuart Smith get there? He has a number of important points in the judgment that get him there. Firstly, he goes through all of the historic authorities in this area, all the way back to the 1950s, cases like McGee and Bonington. They're all analysed in the judgment, and basically Lord Justice Stuart Smith says those cases specifically spoke in terms of indivisible injuries. Whatever the actual type of injuries that may have been in play in those cases, the judgments all considered indivisible injuries, and they all said that material contribution applies. The second thing that he says in Holmes and Poeton is that one of the key authorities which stood in the way of material contribution, a case called AB and MOD, which was a Court of Appeal decision in the Atomic Veterans litigation, that was the most important authority, which until now said that material contribution doesn't apply in indivisible injuries. Lord Justice Stuart Smith says that that decision was wrong, so it's directly criticised now. And thirdly, which I think is quite important, is Lord Justice Stuart Smith tidies up some of the problems that there were in the Williams and Bermuda case. That was another, what I like to think of as an important case, having been involved in it myself, but there were a number of problems with that judgment, and Lord Justice Stuart Smith tidies it up and says that though there were problems in that judgment, but the core of that judgment, which also applied material contribution, is correct. So where does this leave us now? Personally, I don't think that this judgment is likely to be the last word on this topic. It's clearly a very important issue, and I think it's ripe for consideration by the Supreme Court in a suitable case, and quite possibly in Holmes and Poeton itself. The Court of Appeal judgment is a very clear and very strong one, but I'm sure that there are many arguments that could be had in the Supreme Court on this area. In particular, some of the old cases that are relied upon, I think they simply didn't have that distinction at the time clear in their minds between divisible and indivisible injuries. So reliance on them to a significant extent, I think, is possibly questionable. And also in this decision, there isn't a very broad consideration of causation in the law more generally. It's quite narrowly focused in the cases that it considers. So I think the issue is ripe for consideration at an even higher appellate level. What are the lessons to be learnt in terms of instructing experts? Because I think that's going to be a key practical consideration for people in the personal injury and clinical negligence area. Firstly, experts will need to consider whether they are dealing with a divisible or an indivisible disease, because that may have a significant impact on the case going forward. Secondly, an expert will need to consider, is the case that they're dealing with one to which the material contribution analysis can apply, i.e., is there a sufficient scientific basis for concluding that whatever the negligent agent has been, that it has in fact contributed to the onset of a disease. So in Holmes and Poeton itself, although the principle succeeded of material contribution, the claim then failed on the facts, because the Court of Appeal said, well, the science just isn't there in relation to Parkinson's disease to allow the court to come to a conclusion that the solvent, in that case, TCA, had actually played a role. So experts will need to consider whether the science is there adequately to allow them to come to a conclusion that there has in fact been a contribution of the negligent agent to the disease. Thirdly, experts will need to consider whether any contribution has in fact been material, and the test of materiality is of course the de minimis test, i.e. Has the contribution been more than minimal? And fourthly, experts will need to consider whether, even if there has been a material contribution, whether in fact it's likely that the injury would have occurred in any event, because in that case the defendant will still succeed if it can demonstrate that the injury is likely to have occurred in any event. So whilst in terms of principle the decision is one which is in favour of claimants, in that it now is authority for the proposition at appellate level that material contribution does apply, the judgment also demonstrates that there are likely to be evidential difficulties in cases of this type. Because ultimately, if a claimant thinks that they're going to struggle to demonstrate that the but-for test succeeds, they may well, for those very same reasons, go on to struggle to demonstrate that there has in fact been a material contribution of the negligent cause to their injury. So it's a judgment which in a way is balanced between claimants and defendants, and really demonstrates the difficulties in this area of the law. But as I say, we don't think that it's likely to be the last word in this increasingly important area. Certainly in the clinical negligence and the personal injury sphere, I see material contribution arguments arising with ever more frequency. So we're likely to hear further on it. I'm now going to pass over to Howard Palmer-Casey.
Thank you, Andrew. I'm going to deal with a few of the takeaway lessons and principles that can be derived from this decision. The first is the repetition and maintenance of the rule that the burden of proof of causation of damage lies firmly on the claimant. It's very tempting for the courts to make a rule that once negligence has been established, the burden of proof is reversed, and it falls to the defendant to prove that his negligence didn't cause the claimant's loss. Perhaps this would be a fitting punishment for a defendant who has behaved negligently, but such a rule has been consistently rejected by the courts and is rejected again by the Court of Appeal in conformity with the old cases such as Wiltshire, the Poeton, McGee, and several others. So the burden is on the claimant throughout. The second takeaway principle is that where the tort is a contributory cause of a single and indivisible outcome, even though it's not the sole cause, and its contribution is more than de minimis, which is not a high standard, then causation of the outcome and the damage caused thereby is established. The converse of the above is that where there's a multiple and divisible outcome, the rule is that the tort has only caused that portion of the overall damage which is attributable to the extent of the tortious conduct. This accords with cases such as Holtby and Thompson and Smith's ship repairers, which was mentioned by Andrew. These are old cases which are still good law. Going back to single and indivisible outcomes, the third principle is that once contribution to the outcome is established, then the whole of the damage is claimable. This phrase, the phrase used is in solidum, i.e. the tort may be one of many contributory causes, some demonstrating tortious conduct on the part of other persons, perhaps, some being natural or genetic processes or conditions, such as an eggshell skull. But the damage contributed to by the tortious conduct established against the defendant is recoverable in full. The next principle to keep in mind is this. Proof of some contribution to the single indivisible outcome is sufficient, but proof merely that the tortious conduct created a risk that the outcome would eventuate is not sufficient. This principle is derived from the whole Fairchild saga, and its existence gave rise to the famous Fairchild exception. Thus, there is an exception in cases of mesothelioma, which is uniquely caused by exposure to asbestos dust, where it is impossible to identify whether multiple exposures combined to bring about the disease, or whether the cancer was generated by a limited number of anonymous asbestos fibres from an unknown source. Now, the exception in Fairchild could theoretically be extended to other conditions such as Parkinson's disease, but then the claimant would founder on the rocks of the decision in Barker that a cause of action justified by the increase in risk of a disease such as mesothelioma results in an award of damages proportional to the increase in risk brought about by the defendant's tortious conduct, and not damages in solidum for the actual condition suffered. The decision in Barker, of course, was reversed by statute, Section 3 of the Compensation Act 2006, but that reversal relates solely to mesothelioma and would not apply to a new exception if it was argued for successfully in the case of Parkinson's disease. And so Mr. Holmes didn't seek to put his case in that way, because he would have only, if successful, would have only been awarded a partial award of damages. Let us now concentrate on causation of an indivisible illness or injury, which Parkinson's disease clearly is. What was argued by the defence, unsuccessfully, was that the claimant had the burden of proving that had the tortious conduct not occurred, Mr. Holmes would have avoided contraction of Parkinson's disease. This is the so-called but-for test. What the judgment does is to demonstrate that the imposition of such a test does not represent the law. Contribution concurrently with other causes is sufficient according to this judgment of the Court of Appeal. In any event, the but-for test is merely a tool or a cross-check to assist the judge to decide his task, which is whether A caused B, or to put it more accurately, whether A was a cause of B. In the law of tort, concepts such as proximate cause, which is of importance in insurance law, have no real part to play. It's always been enough for the claimant to show that the tort he complains of was a partial cause of the resultant condition he seeks compensation for. Now, there are plenty of situations in which the but-for test is satisfied, but causation in law is not established. And one immediately brings to mind the famous poem, "For want of a nail, the shoe was lost, for want of a shoe, the horse was lost, for want of a horse, the rider was lost," and so on. "For want of a battle, the kingdom was lost, and all for the want of a horseshoe nail." that would not amount to causation in law. At the other end of the scale, there are many situations where two tortious events combine to cause a single result. Yet a rigid application of the but-for test would deny damages against each of the tortfeasors. For instance, two fires started independently and tortiously, which combined to burn down the claimant's property. Or two negligent hunters who simultaneously discharge their weapon negligently and each shoot the same person, in respect of whom each shot would have proved fatal. These are examples of cases where the courts have consistently opined that under the law of causation, both tortfeasors would be liable for the whole of the damage, and neither of them would be allowed to claim that under the but-for test, their contribution was irrelevant. There are also examples in the law of nuisance where the actions of several landowners, say in developing land with insufficient attention to attenuation of rainfall runoff, combine to cause a flood from rainfall which travels to the local river and causes it to burst its banks. The individual quantity of runoff from each of the landowners could in each case have been accommodated by the river, but the combined total was too much. It's generally accepted that each of the landowners is liable in full for the nuisance caused by the flood, whether sued in nuisance or negligence. So a classic case in property damage cases where a combination of contributory causes is sufficient to create liability in each defendant. It can also be said with confidence in tree roots cases that the claimant needs only to prove the contribution from the tree root which he blames, for which his neighbour is liable, is a cause and a contribution to the subsidence complained of. It is not necessary to prove causation on a but-for basis. Now, this makes all these cases very fact-sensitive. They are more complex. The case which Lord Justice Stuart Smith was dealing with was a difficult one, and as Andrew has said, ultimately it couldn't be shown that the exposure caused by the tort or the negligence of the employer was actually a contributory cause of the Parkinson's disease which Mr. Holmes suffered. There are many different types of combined causation. In McGee and National Coal Board, the indivisible condition was dermatitis. The known causative agent was brick dust. The caking of the claimant with brick dust was itself non-negligent, and the only question was whether the dermatitis was caused by the claimant's negligently being denied showering facilities and extra caking resultant on the negligence contributed to the eventual condition, which was dermatitis. In Wiltshire, on the other hand, the eventual condition, retrolental fibroplasia, or RLF, could have been caused by one of 5 separate and independent causes, only one of which was the negligent administration of excess oxygen to the claimant by the defendant. The negligence increased the risk that the baby would suffer RLF, but it couldn't be shown to have actually contributed to the eventual injury. Therefore, the claim failed. The Poeton was rather an amusing insurance case in which several possible and independent causes of the foundering of a ship were considered, from an uncharted rock to simple lack of seaworthiness to an accidental collision with a submarine. There was no possibility of a combination of causes, and so the judge's task was to find a single cause on the balance of probabilities, or to find that the claimant had failed to discharge the burden of proof of establishing what the cause of the foundering was. And the Supreme Court, or the House of Lords in those days, found that the burden of proof had not in fact been discharged. An interesting case to consider is the one of the straw, negligently applied, that broke the camel's back. Here we have cumulative but separate causes, leading to a single indivisible injury, viz. The broken back. Liability may be fact-sensitive. Camels' backs are meant to be loaded, but not overloaded. The facts may disclose that some of those supplying the load lawfully applied their load, whilst others were negligent and ought to have known that they were guilty of overloading. Both groups contribute to the injury, but only the negligent parties are liable, and all those negligent parties will be liable for contributing to the indivisible injury, viz. The broken back. The party which provided the final straw would not be the sole party liable. Indeed, if it was genuinely only one straw, he might escape liability on the basis of the de minimis principle. But one can see that these sorts of cases can be discussed and considered from different angles, dependent on different facts. I'm sorry that this remote format of talk doesn't permit questions and discussion of different scenarios. I can, however, recommend this book, I should say. I was going to recommend my book, but I was going to say that I can recommend this particular case of Holmes as providing many useful answers. As you may know, we have recently published a book called The Law of Property Damage, which does consider very few of these difficult causation questions. And I would certainly be interested in discussing this sort of problem in a wider context. That's all I wanted to say. Thank you very much for coming. Thank you from Andrew and me to all of you. And I shall say farewell.